And welcome in, folks. You're watching First Coast News' online coverage of a murder trial in Brunswick, one that has gained national attention. We're talking about three men right now charged in the shooting death of Ahmaud Arbery, all charged with murder. Travis McMichael, Gregory McMichael, and William Roddy Bryan. At this point, just yesterday, the defense, they rested their case. So now we have the state and the defense rested, and we are expecting on Monday for closing arguments. Huge deal. Can you turn that down for me, Casey? So we're all looking forward to seeing where things will go in this trial. But today is an important day as well. Today is going to be the charge conference. Now, the jurors will not be in the courtroom today, but we will be able to listen in to see what's going on. We're going to have the state and the defense. They're going to hash things out to figure out exactly what evidence they can present to the jurors. And joining us right now via Zoom is well-known trial attorney Richard Kuritz here in Jacksonville. Richard, I really appreciate you joining us because I know you have another trial you have to go to in a matter of just 30 minutes. Before I even ask you anything, I want your take on how things are going, what you've seen thus far, because you're always so candid and open about things. So I'm going to give the floor to you.
Well, I did that. It's been a very interesting trial. It's been a lot of moving parts that have been going through it. It's the defense lawyers are intriguing personalities, and the prosecution is as well. I was actually kind of impressed that they put at least one defendant on the stand to talk and to explain. And I think the jury needed to hear his version of what he felt at the time. And I think that was important.
Do you felt it helped or hurt the defense at all, or perhaps both? Depends on who's listening, right?
I want to think that I will disagree with different analysts. I tend to, if you've tried enough homicide and death penalty cases as I have, sometimes the jury just wants to hear what the heck was going on in your head. And I thought he presented well. I watched your coverage last night, and I watched the news stories. And he was calm, and he explained how he felt at the time. And that's what I think the jury needed to hear. Now, how does this end as far as a verdict? I have no idea, of course, but I do think he did well, and he did need to explain how he found himself in that situation.
So just to clarify for folks who are just now tuning in or trying to figure out exactly who we're talking about, we're talking about Travis McMichaels. He is one of the three defendants right now on trial for murder out there in Brunswick, Georgia, connected to the shooting death of Ahmaud Arbery. Travis McMichael is the man who actually pulled the trigger and shot Ahmaud Arbery. He's saying it was in self-defense. That is the argument, as a matter of fact, for all three of the defendants. Travis McMichael took the stand on Wednesday. First question by the defense, of course, and I heard it from several analysts. They did a good job on the stand, but I want to talk about Thursday, Richard, and what was said on the stand. So when the prosecution questioned Travis, I'm going to give you exactly verbatim. I want to take your take on this. So Travis McMichael was asked about did he feel threatened by Ahmaud Arbery? So he said, Travis McMichael said, yeah, he did not threaten me verbally. Prosecution said he didn't brandish any weapons. Travis said, no, ma'am. Prosecution said he didn't pull any guns. His response, no, ma'am. What do you think that did in the minds of the jurors? What were they thinking after hearing this?
Well, when you deal with self-defense, if you go to a knife fight, you can bring a knife. If you go to a gunfight, you can bring a gun. So this is a situation where the victim in this case did not have any weapons on him. So you have to step back and go, what force can I use? In criminal defense, is force can be met with force. And this situation, while he was credible and believable and seemed remorseful, the extent that he went and grabbed a weapon against Mr. Arbery might have been extreme, but I think the jury just needed to get to hear from him to get a sense of his feelings about what was going on, because most of us have never been in that situation where we were dealing with that kind of situation. And I thought he explained it well, but as far as the law is concerned, and what's going to go on today is the charge conference, which is basically the jury instructions, which is honestly the most boring portion of a trial.
But important.
But it's incredibly important. Most of the cases that ever get reversed on appeal are on charge conferences and jury instructions. So today is very important, but what he did in taking the stand was very brave. And I never, ever want to hear my client's words coming off a witness stand unless I feel strongly about it. And I thought he did well. And I think the jury needed to hear it.
I want your take on this, Richard. Why we did not hear from William Bryan or Gregory McMichael, Travis's father, and the neighbor who actually recorded the cell phone video of that shooting death of Ahmaud Arbery?
It comes back to my comment that I never want to hear my client on the stand. I never want to hear him testifying. I would rather just, let it go from what it is. The reason they didn't testify, it's all on video. It's all been seen. Like so many cases, if the evidence is already out there, unless you have a real use for it, then there's no reason to put the other two people on. The fact that he took the stand to explain his emotional aspect of it, I thought was very brave. And, whether it does or does not impact the jury, I don't know. We don't know. But I think that was a good move. I might have considered doing that as a trial lawyer.
We also saw Travis actually cry at a point on Wednesday while he was being questioned as he described the moments before, during, and after shooting Ahmaud Arbery. He got pretty emotional on the stand. And what's going through the mind of jurors seeing that, in your opinion?
That's actually very important because I've won murder cases and homicide cases or got lesser included because when the jury steps in to the courtroom, they begin looking at the defendant. And when they start looking at the defendant, they begin to get beliefs about their person, their personality, and where they want to go. And it turns into more of an emotional aspect than most people think. So the fact that he took the stand and was emotional, when it's credible, that's the deal. When it's not credible, then the jury will check out in a second. But if the jury starts to believe that you're credible and you felt that, that's a huge impact. But there's that 1 second where if you do not seem to be credible and believable, the jury's gone. And then it's going to be a guilty verdict in a second.
And in your opinion, he did come across as credible?
I thought he did.
Okay.
I thought he acknowledged everything. He acknowledged that there was no weapons. He acknowledged everything, but he was, trying to explain, and I thought he was credible.
Okay. I want to ask you about this because we had a chance to talk with Lee Merritt last night. He is Ahmaud Arbery's mother's attorney, Wanda Lee Cooper Jones, and he says that the prosecution plans to push that a citizen's arrest defense doesn't make sense in this case. He's saying that the defendants have testified they never saw Arbery commit a crime, which is needed for this particular defense. Your opinion about that? Is that something that you think will actually be thrown out, the citizen's arrest defense? If so, we would think that'll be pretty damning to their case, the defense.
I do not think it'll be thrown out because, I will say it should not be thrown out because, as I said earlier, when you come to jury instructions and like charge conferences going on today, the number of cases that get reversed on appeal are because the jury was not instructed properly. There's no harm in allowing that instruction. If you deny that instruction, then we'll have problems in the future, which leads us to a whole nother conversation about where this case is going with all the 700 ministers that are there and what could cause a problem on reversal, because what the family wants, of course, is closure. And this case is probably not going to be closed anytime soon.
You need to expand on that, Richard. What do you mean?
What I mean is there are cases in Jacksonville and in Florida that when you have 20 police officers show up in uniform and sit in the front row to show a presence to, I don't want to say intimidate a jury, but to influence a jury, they've been reversed on appeal because it was an improper attempt by the state or the government to influence the jury. And now what we have in this case is clearly a great attempt to influence the jury by bringing in, Al Sharpton and Jesse Jackson and, all these other ministers. Now, I'm not saying the state did it on purpose by any stroke of the imagination. I don't think the state had anything to do with it. But you have that kind of influence on a jury that subjects the case to being, if there is a conviction, to coming back on appeal and getting a new jury.
So you are predicting that will likely happen in this case. Is that what you're saying?
What I'm saying is, if there is a conviction in this case,
okay.
And if I were the attorney on appeal, I would have all kinds of issues to argue. Okay. I would be able to argue the improper influence on the jury. I would have all kinds of things to argue. We hope that we get peace in this case. We hope that the family gets peace and it's over. But I've done this long enough to know that there's a great chance this case will be heard again based on what I'm watching so far.
Wow, that's interesting. Richard, you've been pretty critical and openly so about what you're seeing in the courtroom over the past 5 weeks. Your take on things over this last week, because we saw a lot transpire both inside and outside of the courtroom. Your take overall on what you've been seeing so far this week.
I thought the prosecutor is doing a very good job. I think that she's doing everything she's supposed to do with the evidence that she has. I think that the defendant who took the stand did everything he was supposed to do. I think the defense lawyer, who is kind of an obstructionist, but he's making all of the correct objections. So while there's a lot going on, I am not critical of the lawyers that are involved in it. I don't know where the improper influences are coming from, but it's not a typical case that you would try in Florida. Let me say it that way.
Okay. Well, I'm going to say this. You did as well. I mean, you would have never had William Bryan as a part of this case in the first place. You said that it would have been severed a long time ago. He would not have been tried with these defendants, correct?
That is
if you were representing him.
That is absolutely correct. I am very surprised that he was sitting there. I thought he would have been a cooperating witness. I think he would have been severed out of the case. All the arguments about trying to get it severed that were going on even during the trial were wrong. And I was obviously correct, and they were not severed in the middle of this. Should have been done a long time ago. That would be my only critique of any of the lawyers that I've seen.
Yesterday we saw the defense, they rested their case. We saw Goff stand up. We were waiting to see what is he going to say. Is there an actual defense? Nothing about the actual case, though we've heard from him several times throughout the duration of this trial. Your take on that? You actually think that was a smart move on his behalf, correct?
I do, and it's one of those things that I try to tell the jury when I'm in jury selection is you're going to hear me argue, you're going to hear me cross-examine witnesses, you're going to do this, but what people don't understand that I try to teach the people in jury selection is their witnesses are my witnesses. Therefore, I may not call a witness during trial because they've already called them. And so therefore, what I would do is, obviously my questions are through cross-examination. And so I don't need to call a bunch of people back. Now, I have done that in the past where I call every one of their witnesses back. But in this case, it's on video. He is taking the stand. There's really no additional witnesses to call. So the fact that the other two did not take the stand does not surprise me. It's actually the move I would have made.
Yeah. All right, folks, if you're just now joining us, you're watching First Coast News' online coverage of the murder trial in Brunswick. We're talking about 3 men charged with murdering the shooting death of Ahmaud Arbery. Ahmaud Arbery was a 25-year-old shot and killed in the Satilla Shores neighborhood of Brunswick, Georgia, back in February of 2020. Fast forward now to November of 2021. We know both the state and defense, they have arrested their cases. We're expecting closing arguments to begin on Monday, but prior to that, today, a very important day inside of the courtroom, though the jurors won't be in there, but we're going to hear from both the state and defense. They're going to be talking amongst each other, really. We'll just be flies on the wall listening in. They are going to decide what evidence will be presented to the jurors. Richard, I'd love to put you in the shoes of the defense because it's always interesting to hear your take on that. If you were the defense in this case, what evidence would you feel as if should not be included or should be? What would you be fighting for?
Well, and I hate to ever correct somebody on this. Mm-hmm. It's not about what evidence is going to be presented.
Okay.
The evidence has been admitted to trial. So during the course of the trial, where we're at now is how do we instruct the jury? Is right. It a first?
Well, you're the expert here, Richard. We want to hear from you. Go for it.
Yeah. You mentioned what evidence the jury is going to. They've already heard all of the evidence mm-hmm. and arrested. So now, when you deal with a trial, it's the evidence that the jury gets to hear, right. And then the judge is going to instruct on the law. And that's what happened today. Today is everybody's going to sit down. Both sides are going to talk back and forth and decide what law the jury should be instructed on so that they can have the jury instructions to go into the back. And when they go into the jury room, they will know. They've heard what they've heard, but now what is the law that applies to it? And so what's going to happen today is it a first-degree murder? Is it a second-degree murder? Is it a manslaughter? Is it a reckless manslaughter? Was it self-defense? Was it a citizen's arrest? So the evidence has already been admitted. So that comment is out the wall. So now it is, what is the jury going to be instructed on so that they can hear and look at? And in my trials, especially in the homicide and death penalty trials that I have each different juror have their own packet of jury instructions. So they not just the foreman, but every single one can look through it and go through, do I believe this to be first degree premeditated? Now, do I think this to be second degree there? Or do I believe this to be simply a manslaughter? Do I think this is reckless behavior? Do I think whatever it may be? So you go through the jury instructions, and that's what's going to go on today. It is definitely the most boring part of the trial, but it's important because if the judge does not instruct them properly, then we come back to the idea of a reversal on appeal. So today is going to be simply what the law is going to tell the jurors, if that makes sense to you.
It does. Richard, there's a reason you're sitting in that chair. There's a reason we call on you. Your expertise is appreciated. I always want to hear from you, so feel free to chime on in when you feel you need to. I'm okay with that, definitely so. Now, I want to talk about what's going on outside of the courtroom yesterday. You saw the video. I mean, the lawn was just filled, packed with people, pastors, all races, all denominations, as well as a lot of demonstrators. A lot of people were out there in support of the Arbery family, very openly so about it. We saw the signs from so many people chiming in saying they wanted justice for Ahmaud. I know this is something that you would not be okay with as a defense attorney in this case. I did see the defendants being brought in through the back of the courthouse very early in the morning, even before the protesters were coming in there. Any chance the jurors saw what was going on?
There's 100% chance the jurors saw what was going on. But this jury was not sequestered. You say they were not put up in a hotel room. They all go home at night. I'll talk to their husbands and wives, and they are, it is what it is. I mean, that's when this little community has a case of this magnitude, we cannot actually, like, we're in a vacuum and that is not real. I mean, they know, they watch, they see, they can't avoid it. That's why I was saying that this case, when one of our previous conversations with you, that it should have been moved to maybe Atlanta or at least Savannah to, get a jury pool that's not going to be tainted. And so to think, I mean, no one, if we're being intellectually honest with ourselves, there's no chance in the world that this jury does not see this, hear this, and feel this. So that's where I, as defense lawyer, have a problem with this case, is it should have been moved. And there's no way the jury doesn't know everything that's going on.
Well, Richard, I only have you for about 3 more minutes. So if we can quickly, let's look ahead. What do you see happening on Monday in terms of the closing arguments?
No, I think and I was telling you, on track. There's no way in the world it was going to be passed till after Thanksgiving. I 100% believe they'll begin the closing arguments on Monday. The state will obviously go first. You have 3 different defense lawyers, so I would like to think most closing arguments end in one day, but because you have 3 different defense lawyers, there's a real chance that it might bleed over to Tuesday. I expect what I call a charge conference, when they actually charge the jury. There's a charge conference, which is taken today, but then the judge is going to charge the jury. And I expect that to happen on Tuesday. So I believe the jury will begin deliberating on Tuesday afternoon. And of course, they're all going to be thinking about their Thanksgiving. So I think there's a real chance we're going to have a verdict Wednesday. And if I was a betting man, I'd say 6 o'clock Wednesday night, we'll have a verdict.
If I was a better betting person as well, I'd go with what you have to say. I have to give you guys some inside baseball. Anything I had a question about in this trial, I just text Richard quickly, and he responded. And I sat back. I said, is that actually going to happen? Every time you've been on point. I'm going to give you that much, Richard. I'll give it to you. Thank you again for your time. We really do appreciate it. And I know you said you have court at 9 as well, and we're going to go ahead and wrap this up. But again, things are not going to start out there in Glenn County until 10 o'clock this morning, so there's going to be a little bit of break. We want to thank you guys for joining us, and thank you, Richard, again. We appreciate your time, and good luck today in court.